Good afternoon, everyone. Welcome to our Construction Law 101 series. I'm Greg Smith at Smith Kimbrell Russell. I'm standing in for Todd, Hefner, who has been running these series of Construction Law 101 webinars, but he is in a deposition today. I want to remind everyone of an upcoming event on December 1st, where Brad Parrott will be talking with us about common construction claim types. And then coming further in January, and at the beginning of next year, we'll have a series on working with experts, a call on construction contracts and subcontracts, and then an introduction to changes, differing site conditions, and key risk shifting provisions, which is something that we all deal with. To jump straight into our program today, to give our speakers the maximum amount of time, would like to introduce Chad Reynolds. Chad's a litigator in Chamberlain's construction law, commercial civil litigation practice groups. He's joined by Andy Ackel, who is a managing director at Glass Ratner, being a forensic accountant and economic damages experts. I'll let those guys maybe introduce themselves a little further, or just dive right into the presentation. And turning it over to you, Andy and Chad.
Sure. Thanks, Greg. Chad, you want to take the honors?
Yeah, thanks everyone for attending. Andy and I are presenting on the topic, this Construction Law 101 series, the Introduction to Construction Claim Damages. And this is going to be sort of a general overview or a base understanding of these types of claims and the damages that occur. So we won't get too specific, but we will hopefully cover a good bit of material for everybody. Um, and as Greg said, I'm senior counsel at Chamberlain Herdlicka in their construction and litigation, commercial litigation group, representing owners, general contractors, subcontractors in litigation and transactional matters, and all types of courts, arbitration, and things like that. I'll hand it over to you, Andy.
Yeah, thanks, Chad. My name is Andy Ackel. I'm a CPA and economic damages expert, a managing director at Glass Radner here in Atlanta, and have been calculating damages in a broad range of legal disputes for over 18 years. I've testified in deposition and at trial at state and federal courts, as well as ADR venues such as mediation and arbitration. So let's kick things off here. Let's see. Here we go.
Yeah, so just a brief introduction. With these types of claims, the most common type is going to be a breach of contract claim between the parties. And in that case, the terms of the contract are going to govern. So whatever your contract says about certain damages, primarily what you're going to be looking at. And generally, each party, when they sign a contract, they're expecting that it's going to be carried out according to what's in the contract, with no surprises. But of course, that does not always happen. Uh, the rationale for contract law is to protect each party's economic expectations at the time they entered the contract. And, damages will occur when the party's expectations are not met, when things go awry. If I'm an owner, I expect the project to be completed by this date, but now it won't be completed until a later date. So there's going to be a breach of contract or damages that somebody will be looking to obtain. And damages typically must arise directly from the breach of the contract, and they must be somewhat foreseeable. And to prove your damages, you must show that there must be a quantifiable amount of money. There must be some reasonable degree of certainty as to the amount of those damages. Typically, you're not going to be awarded damages if they're too remote or speculative. Um, Contract damages don't call for punitive damages or pain or suffering or any other types of damages that would be outside of typical contract breach. Sometimes you can get the recovery of indirect or consequential damages. These are damages that are a bit more remote, They still can flow from the contract, but are a bit outside of the party's expectations. Sometimes those can be allowed, but they will be usually limited by certain clauses in the contract, either limiting or excluding those types of contract damages.
All right, just to take a step back and kind of orient everyone, these are the three types of damages theories that are most likely that you're most likely to see in contract disputes. On the left, starting on the left side, we have reliance damages, which typically focus on costs incurred in reliance of contract performance, or said another way, wasted costs that once returned would unwind a contract and put both parties in the same position as they were before they entered into one. A simple example of reliance damages, say you hired me to paint your house for $5,000 and I went out and spent $500 on brushes and paint. My damages under reliance theory would say that my damages are $500 because that's what I spent on paint and materials in reliance of your promise to retain me. The middle circle here, restitution or unjust enrichment, typically focuses on the defendant's gains or benefits with the goal of stripping those benefits, whether they're saved costs or increased profits, and giving those benefits to the plaintiff. It's equitable relief. It's not punitive, but they're also unrelated to a claimant's loss. It's what the defendant gained. The concept is not something you see a lot in construction disputes. Most often, and you see that in intellectual property disputes like trade secret misappropriation, where you're able to recover both, your loss and their gain to the extent they're not duplicative. Restitution and reliance assume that you unwind the contract. The only difference in reliance damages is that you're taking back your wasted cost, whereas in restitution, you are disgorging the benefits that the defendant or respondent received. The third theory is what we're going to be spending most of our time on today is the expectation theory or expectation damages. Most contract disputes are calculated under the expectation theory of damages. Here you're calculating the difference between what the injured party received or expected to receive when it executed the contract versus what it actually received. So the key difference between expectation and the other two is the benefit of the bargain. In expectation, you are assuming the contract was entered into, and you're calculating the difference between performance on one hand and non-performance on the other. Whereas the other two, you are assuming the contract doesn't even exist. So in my simple example of you hiring me to paint your house for $5,000, my loss under the expectation theory would be my lost profit margin on that $5,000 after backing out my costs. So regardless of the damages framework, the plaintiff or claimant has the burden of proof. As I'm sure we all know, the standard of proof in most civil disputes, setting aside matters of fraud or punitive damages, is a preponderance of evidence, which means that it is more likely than not to have occurred, or the 51% rule, as some people refer to it as. So, given this construct, what are the keys to proving damages in a contract dispute by a preponderance of the evidence? In my experience, number one is entitlement. You must be able to demonstrate that the law allows for the recovery of the damages you're claiming, typically either through contract provisions or case law. The next one is causation. We'll talk more about causation on the next slide, but you must be able to link the defendant's actions to the damages claimed. And the third thing is that damages must be proven to a reasonable degree of certainty. So speculative or unsupported figures won't meet that burden. The reasonable certainty standard, at least based on my research, was crystallized by a case in 1931 called Story Parchment. It was refined in 1946 in a case referred to as Bigelow, and then ultimately codified in the Restatement of Contracts in Section 352, and then reinforced many, many times over across different jurisdictions and courts and leading treatises and cases like the Faust versus Parrott example here. So focusing on proof and again going back on causation, from my perspective, construction cases are somewhat unique from a damages perspective from other contract disputes, such as a run-of-the-mill, supply agreement contract, something like that. First of all, because of the numbers of parties involved in a construction project is vast relative to most contract disputes. But also, outside construction, damages disputes typically focus on the but-for world, and forecasting the but-for world. What does the world look like if performance, assuming performance of the contract? And then the argument in those cases often becomes, what is that X? What does that look like? We would have made X dollars, but for your breach of our supply agreement, what does that X look like? Whereas in construction disputes, a lot of the time, the but-for world has already been established and agreed upon, at least to some extent, through some form of budget estimate, be it a GMP or otherwise. And also in construction disputes, there are typically no disputes over whether there was a delay or there was an acceleration or there was a disruption. And often the amounts, over budget are typically not even in dispute. So the focus from my experience in construction disputes often becomes whose fault is it, right? And with that, establishing the causal link between the additional costs incurred on the project and the action or inaction of one or more of the parties becomes the focus. So, given that construct, two things for you to think about as you advise your client. The first is what contract mechanism is going to allow for recovery in the event the project goes awry? What are the change order provisions? What are the excusable delay provisions? What are the liquidated damages provisions, termination provisions? Is it a GMP? Are you claiming negligence, which is obviously a tough standard? What part of the contract did they breach? The second, and more important from a damages perspective, is what documentation do you have available to support your claim? Detailed contemporaneous documentation is often the key to recovery. Maintaining contemporaneous documentation regarding what is happening on the project, in real time, and details regarding why those things are happening can be paramount. There's some examples listed here: daily, weekly, monthly reports, meeting minutes, robust, product costing systems that allow for sufficient detail, the ability to create new cost codes as issues arise, that can help you to segregate those costs and cost overages, budget details. You should be able to understand what assumptions went into each budget line item. Why is this piece of equipment expected to be $1 million? Where did that come from? What are the underpinnings of that estimate? Detailed change orders and change order logs that provide as much information as possible on what conditions led to the change order. Again, you may be able to get some of this from expert testimony or fact witness testimony or some sort of ex post analysis, but the documentation created contemporaneously as the project was happening is likely going to be your most powerful weapon for recovery.
So talking about damages, one of the other principles in this arena is mitigation, your duty to mitigate. And a party cannot simply sit back and let the damages occur while doing nothing. If you own a building or you're a tenant or own a home and there's a hole in your roof, you can't just sit there and let the rain come in and literally take a picture of it, point to it, and tell the owner or whoever, the contractor, you're going to pay for this. The court is going to say, all right, let's be reasonable here. If you knew the storm was coming, maybe you should have put a temporary tarp over it, done some type of mitigation to either lessen or prevent any further damages. Um, and this requirement or this duty to mitigate, we have to look at what specifically is mitigation. And here we've got Black's Law Dictionary, and it's saying that the principle requiring a plaintiff after an injury or breach of contract to make reasonable efforts to alleviate the effects of the injury or breach. And if the defendant can show that the plaintiff failed to mitigate these damages, the plaintiff's recovery may be reduced. And I wanted to focus on, again, these reasonable efforts to alleviate the effects of the injury. You're not required to use every single thing underneath the sun imaginable to mitigate damages. It's what's reasonable and using your and exercising ordinary care. What can you do to limit the damages that are going to be incurred? And what is reasonable obviously depends on the circumstances. So the type of damage that's occurring, when it's occurring, where it's occurring. And in certain cases, if you have a delay, and you're a general contractor, if something slows down or there's a stop, how long should your laborers be on the project and remain idle? Same thing with equipment. If you have equipment sitting around not being used because there's a delay in the project, and you're paying a daily rate or a weekly rate, what is reasonable to try to mitigate those costs? If the time is unknown and you expect it to be pretty short, there may not be a lot of mitigation that can be done. And so in that case, there's not going to be a high expectation or a big expectation that you take certain efforts to decrease those costs if they're only going to happen for a couple days. But if they are incredibly easy and reasonable, then maybe that duty might be your duty to mitigate might be higher in that case. But if the delay is known ahead of time that it's probably going to be lengthy, there might be more mitigation that you can do or that would be considered reasonable to minimize those damages that have occurred. If you're on the project and there's a delay, does it get to a point where the delay becomes so long that the project stops and is going to be restarted, or is it just simply in a hiatus for a while? At that point, with your laborers, do you demobilize the project? Is it going to be cheaper to demobilize and remobilize later rather than having those laborers sit around for however long they need to until the project starts back up or the area that they need to work in becomes available? During this time, can you transfer your laborers to another part of the project to work on something else that needs to be done if an area is not ready or a certain activity can't be performed at that time? Do you transfer those laborers to another project or transfer some of them, not all of them? There's many things that can happen or ways that you can mitigate your damages. And again, it simply comes down to what's occurring, where is it occurring, and how long do you expect this to occur? If you know it's going to be a long time, your duty to mitigate is going to be higher. But if you don't know, then it might be a little loose. So here we've listed out the typical types of damages in a construction dispute. We've already talked about some of these briefly, but we just wanted to put them all on a slide so you can see these are primarily the types that you're going to be dealing with your typical construction dispute. So we have your contractual types of damages, and in this case, you're looking at liquidated damages, which is going to be a specific clause. And these are damages that the parties have agreed to ahead of time to estimate a certain dollar amount of damages for delays. So depending upon the context and the parties involved, the clause could say owner is entitled to assess liquidated damages at $1,000 a day for every day the project is late. And that amount of money can change depending upon the circumstances. What are the owner's reasonable expectations? Is there a tenant involved? Can we anticipate to some reasonable extent what it's going to be? You try to get a number that's close, and then every day after, per day, that cost can be assessed by the owner against the general contractor. And then you have your typical direct damages, which are going to result from scope changes, delay, acceleration, disruptions, which we've briefly touched on. Your scope changes are going to involve an increase or decrease in the amount of work or the type of work that your contract calls for. And these damages, they can be agreed upon by the parties in a written change order. And that can be an increase in costs, additional labor that's going to be paid for, obviously the cost to do the additional work, or the costs that you would be saving for taking out certain scopes of work. And it can also include a increase in the time for you to complete the project. You also have your delay damages, which we will get into more detail in the later slides. Your acceleration damages, are the conditions on the project resulting in a party having to work quicker than they anticipated? When you bid on a project, you expect your work to be finished within a certain amount of time, but are things on the project resulting in delays that either impacts your start date or impacts the middle to where you can't perform work for a certain time, but your completion date doesn't change? At that point, you have to accelerate some of your work. And is that happening? And what costs are you incurring? The other one is the disruption damages or other damages. And in this case, is the project sort of disorganized that it results in the parties working inefficiently? The parties working on top of each other or having to piecemeal work in different areas instead of being able to focus all labor on one activity and get it done quickly. That type of stuff. Your labor productivity. Is it being reduced by circumstances that are occurring on the project? I'll hand it up.
Yeah, so the other things we'll be covering today, and we have typical outlined and sort of highlighted here because it's not going to be the case that in every matter these are direct and these are indirect. It should really be a matrix. I mean, any one of these costs can be direct. Lost profits can be direct damages. Scope changes could be indirect. So this slide is meant to sort of portray what we typically see. Regarding indirect and consequential damages, generally we're talking about the owner here claiming these. The types of damages depend on the facts and circumstances of the case. Like I said, can be direct in some instances, but generally include lost profits from the project not being completed on time or to spec, increased insurance costs or financing costs, either from prolongation of the construction period or additional funds, insurance needed, legal fees, municipal fees or tolls or monitorships, that sort of thing. Recovery of these may be limited by contract mechanisms, contract clauses, and even liquidated damages as well. So something to keep in mind for those. Punitive damages we have listed here. We're going to briefly mention that at the end, but it's not something I typically deal with in any event.
All right, so going through these types of damages, we had briefly talked about these direct damages, which are going to be your most common, more easily ascertainable than your indirect. But we have this picture here of this old guy in a wig, Baron Sir Edward Hall Alderson, and he's credited with the Hadley rule, which essentially defines direct damages as those that arise, and we've got the quote here, naturally occurring to the usual course of things from the breach of contract or in the contemplation of both parties at the time they made the contract as the probable result of the breach. And again, the emphasis here is the damages directly flowing from the contract that are naturally occurring or very reasonable or anticipated. Those are your direct damages. We mentioned before that they must be foreseeable, reasonably foreseeable to both parties when they enter the contract. If they're too vague or speculative, that's going to be incredibly hard to prove. Those aren't your direct damages. And as long as you can establish them with some type of reasonable certainty, your chances of getting those damages increases. And that's what needs to be shown when you're attempting to get your direct damages. The reasonable certainty, you don't need to have the exact cost down to the penny. And then a lot of times construction contracts with these, when there's a breach, if you have a delay, these costs are going to be hard to calculate through receipts or things like that. I mean, they're hard to determine. So sometimes estimates are more useful or at least appropriate. But even those estimates must be showing those damages with some reasonable certainty in order for them to be awarded.
All right, so on the other side of the coin, as opposed to direct damages, which are direct and natural result of the breach, we have indirect damages, which occur as a consequence of the breach. Just walking through the slide here, common examples of consequential or indirect damages: lost profits, lost business opportunities, increased financing costs, reputational damages. They're harder to prove in construction disputes and more subject to scrutiny by the trier of fact. Most construction contracts I've dealt with limit or exclude consequential damages and specifically call out lost profits in those limitations typically. However, all jurisdictions in the U.S. that I've worked in recognize some kind of exception to those limitations clauses for some combination of fraud, willful misconduct, gross negligence, or violation of public policy. So gross negligence is one that's commonly claimed in construction disputes, but difficult to prove. What is it? A lot of times the attorneys and experts are sort of staring each other, waiting for an example or for an answer to that question. What is gross negligence and how is it different from ordinary negligence? Cornell describes gross negligence as a heightened degree of negligence, representing an extreme departure from the ordinary standard of care, falling between intent to do wrongful harm and ordinary negligence. Gross negligence is defined as willful, wanton, and reckless conduct affecting the life or property of another. So it's considered more harmful than ordinary negligence because it implies a thoughtless disregard of the consequences and the failure to use even the slightest care to avoid harm. So we've got a couple of graphics up here. One is just Homer over there. I just thought it was a funny graphic, but the other one here is from personal injury context, and it's from a personal injury law firm. And I thought it was interesting as a way to illustrate what gross negligence may look like, at least in that world. You can see some of them here, speeding in heavy traffic. I've certainly done that. Leaving a surgery tool inside a patient, that seems pretty bad. Jaywalking in heavy traffic, no lifeguards at a child's pool, that would bother me. Not fixing a ride at a theme park, that seems to qualify. Not cleaning a spill in a crowded mall. So, ultimately it's going to be fact and case specific. I don't have a bright line answer for you on that question. In my experience, it is in construction disputes, one of the things that, it's kind of one of those things you see, when you see it, things like systemic design defects, disregarding structural or engineering requirements, willful violations of building codes or permitting requirements, or ignoring defects or problems as they arise. So now that we've sort of laid a groundwork and provided kind of the prevailing damages theories and foundational concepts, we're going to spend the remainder of the presentation discussing the various types of damages we typically see in construction disputes, starting with damages for changes in scope of work. As we all know, construction disputes or construction projects rarely goes as planned. That's obviously a biased view coming from someone who only gets a call when there is a problem. But it's often the case that work needs to be added on a construction project or removed in limited circumstances. And this kind of gray blob indicates, scope creep is common in construction projects. Most scope changes are handled through change orders. I'm sure many of us have seen entire projects built through change orders. Typically, those change orders are for additional labor, materials, and equipment to complete the project under the revised scope, along with many times indirect costs, such as additional supervision, additional temporary facilities, or additional administrative costs, those site overhead and general conditions kinds of costs. In my experience, there are primarily two areas of dispute involving these change orders where experts may get involved and damages come into play. The first one is entitlement, and the second one is the pricing of the change order, the quantum. Entitlement, typically you have an owner saying that, we had an agreement in place. You said that you were going to give me this building for X amount of dollars. You should have known as the contractor that scope was always going to be necessary. And on the other hand, you have the contractor with his or her hands in the air saying, yeah, I mean, after that agreement, you changed 20 things, and now we need additional labor, materials, etc., to complete that revised scope. The second issue, a lot of the times, is pricing, as I mentioned. It's a frequent area of dispute among parties and even experts. The number of man hours required to complete the revised scope, the level of supervision needed, the contractual rates are often in dispute. Do we use the standard rate? Do we use the overtime rate? Or is it something entirely different to price this change order? It's also important to understand from a damages perspective, what amount of profit, if any, is baked into the change order line items, whether it's for labor or equipment, or site conditions. If there are profit elements, that change order becomes a claim for additional profits or lost profits in the damages context.
All right. All the work on a construction project, it can't be done at one time. It's pretty obvious. So the work in each contractor or subcontractor, their work has to be sequenced. Some things have to come before other things. For example, you can't put a roof on a building if the walls aren't completed yet. It's just physically not possible. And this sequence of work is shown on a project schedule, which needs to be followed in order for the project to be completed on time. And this is usually comes down from, maybe either the owner or the contractor or some other party higher up, that is that has provided a schedule to say if everything goes according to plan, these are when these activities are going to start, these are when these activities are going to end, and based on sort of the longest path there, that's how we get your completion date. And you know, they should be, as the project progresses, there should be conversation between all the parties, if there are any changes that may impact that deadline or these activities. There should be communication to let everybody know that these delays are going to occur or things need to be resequenced. That should typically happen. It doesn't always, but these schedules can get updated just to show and let everybody know, hey, this is when this is occurring. This is when you come in, things like that. When you know to arrive, where to work on the project, and what activity to perform. But not all delays are going to result in damages, or at least, damages that you can collect underneath the contract. Um, and I think it's important to distinguish delays into two types, your critical delays and your non-critical delays. Because you think, oh, if I'm delayed on the project, obviously I can get those costs. That's not always the case. These critical delays are the ones that do impact the project's completion date. Your non-critical delays are the ones that obviously do not. Um, Now, how do you show if the delay was critical or not? And typically, you need to show that the work that's causing the delay was on the critical path. Now, critical path is defined as, the longest chain of events that's controlling the completion of the project. I provided this graphic here, which is a critical path graphic showing, this as planned schedule. So if you're starting a construction project, there's going to be a schedule at the beginning that shows if everything goes according to plan, this is what it looks like. So here, we have a timely example of Thanksgiving dinner, and this is if you're baking or making the Thanksgiving dinner, this is what you've planned out for preparing the meal. And here's your schedule with everything that needs to happen. Now, the red line is going to be charting that critical path. So if you're cooking the Thanksgiving dinner, no other activities on this chart can start until the food is bought and delivered. And so if you have 2 hours and 30 minutes allotted to that. If you go to the store and they don't have an ingredient you need, and you end up having to go to another store and it ends up taking you longer than 2 hours and 30 minutes to start cooking, then in that case, there's going to be a delay since that is driving the critical path. No other work can be performed until you get those materials and back home. So at that point, you get back home, and while the turkey's in the oven and it's cooking, it's supposed to take 3 hours and 30 minutes. Other things can be going on at that time. Either you're freed up to prepare the side dishes, or other people are working on those side dishes. And you've planned 2 hours and 45 minutes for those side dishes, your green beans, whatever you want. And they're not planned to take as long as the 3 hours and 30 minutes for cooking the turkey. So if there is a delay in those side dishes, it's a delay that happened, but in this case, it's not impacting the critical path. It's not going to be pushing the dinner ready time beyond what's scheduled. So say it takes 3 hours for the side dishes to be prepared. In that case, it's still within the 3 hours and 30 minutes, even including the stuffing, the turkey time. It can still fit within that window. So in that case, you're still 30 minutes for serving, that you still have that time. That time is not getting shrunk for the dinner to be ready. And those preparing the side dishes, if they're delayed, they're non-critical because again, they're not going to delay the setting of the table. And as talked about, these damages are proven by expert testimony. In this case, you're going to have your scheduling expert if you're looking for delay damages and you're trying to show somebody's activity was on the critical path. If you're trying to assess them LDs or you're trying to dispute the costs that they incurred, things like that. So now we're going to look at each party to the contract and how these delays impact them and sort of what damages they're going to be looking at if there is a delay in the project. As we talked about, most changes on the construction project will result in some sort of delay. But the delay can either be excused or unexcused. If they're excused in that instance, you could be entitled to damages or unexcused, not entitled to damages. And this often boils down to, is the delay the fault of the party who's seeking the damages? So for the owner, if you're delayed, what you're going to be looking at is, do you have any extended administration costs on the project? And these will typically be direct damages if you've hired an architect or a construction management company to manage the project. Are they charging you fees? If the project's delayed 3 months, those additional fees are going to be direct damages as a result of the general contractor not performing the work on time. And then you also have, in some circumstances, as we've talked about, depending upon, what happens and what occurs in the project, lost profits. These can be your direct and indirect ones. This can be rent, revenue, profits, and usually, if you have a lease, if you're a landlord, already signed with a tenant and the contractor knows this, you're telling them, hey, this project needs to be completed on this date because my tenant is moving in a week after. Or, if there's a tenant already in there and they've moved out for this work to be performed, if that takes longer, is that eating into the established business revenue or profits? And this is going to be easier to prove if the lease is already signed or if the business has a record of profits that they can show. The past 5 years we've had profits of this much, but because we couldn't get back into the building on time for these months, we had to run at a decreased capacity, so our profits were reduced, things like that. If you have that, your case for proving those damages is it's going to be better. If you have empty space or you don't have a tenant lined up, the delays for the completion of that building, it's probably going to be harder to show lost profits. And if it's a new business too, a new business that hasn't gotten up and running, doesn't have those records of steady profits for the prior years, that's going to be hard as well. Some of the other damages that an owner is going to be looking at is if the project is financed, is there loan interest that you're going to have to continue to occur? Are you going to have to extend the loan? Are there any insurance considerations, bond considerations, things like that have to be extended? Typically, if the project continues, you're going to incur those costs. And the other one is liquidated damages, which we've touched on. And again, this is that contract clause that states the daily rate for each day that's past the completion date. And the liquidated damages clause needs to meet a certain amount of requirements for it to be enforceable. One of those is that you can't use it as a penalty. If you're just simply putting it in because you want to make sure it's completed on time and you want to punish the owner for not hitting their date, it's not going to be allowed. The actual damages must be difficult to determine. As we've talked about, delay damages are hard to prove. You need to involve experts. You're looking at schedules, estimates, and all this types of stuff. So if your actual damages are difficult to determine, you can use the liquidated damages provision to just set up a number and say, this is it for every day that you go beyond the original completion date. Also, the liquidated damages clause is going to have to be based on some type of reasonable forecast of the actual damages that would be incurred. Um, in this case, if it's a small project, you can't put a liquidated damages clause at, $100,000 a day or $1 million a day. It's just not reasonable. And at that point, you can tell it's not a forecast of the damages you would actually incur. At that point, it becomes more of like a penalty. And again, the courts don't like that. But as long as you stick within those factors and there's a couple more, then that clause is going to be enforceable. And that daily rate, then you can pass on to the general contractor and say, these are my damages. And it can be pretty simple because at that point, you're just doing a daily rate and not having to come up with all this other stuff. All right, so looking at any contractor or subcontractor, um, what types of damages they're dealing with. If we have here underutilized or idle labor or equipment costs, these are probably flow more from your direct costs. If you can't work in an area, laborers either have to work in another area or idle or piecemeal work and won't be as efficient. Um, and if the project is only set to be completed in a year, but ends up being 3 years, your salaries may increase, the per diems may increase, things like that. Your increased costs for equipment rentals. Um, again, the cost can be incurred daily or weekly. It's easy to determine these costs if you're renting them from a third party, because at that point you're getting an invoice every day. This is on paper. You can point to a number and say, boom, here are my costs. But it's harder if this equipment is owned by, the owner or the contractor. At that point, you're going to be looking at more tenuous costs like depreciation or maybe replacement value if you're having to use the equipment more. Um, and again, these costs are going to be subject to your mitigation factors. Can you be putting labor in other areas to work on stuff? Or can you put them on another project site and not incur those costs directly for this project? And this is all, you have you have those direct costs, then you have your extended project overhead costs. These are going to be more your salaries for support roles on the project, not your laborers, but the supervisors, the project managers, secretaries, other people who are working on the administration of the project. Also, if it's a big project, you're going to have a trailer, you're renting that trailer, extended costs for renting that trailer even more. And then you have to fill that office with office equipment, printers, computers, things like that. If you're renting that stuff or if you're incurring costs for that stuff, that's going to be additional costs based on this delay. You're having to use that more. And a lot of times these costs, especially with salaries or support roles, even trailers, actual costs may be difficult. So you could break it down at an average daily rate, as long as you've got some type of logic behind it and it seems reasonable, you can then use a daily rate for each day rather than showing, okay, well, somebody was actually in the office only dealing with this today. So dividing their salary, blah, blah, blah. Daily rates can be a lot easier and a lot more functional. The other one is your home office overhead. If you have a corporate office or home office near there, the costs to maintain that, your rental costs, and also any types of salaries for people who are there, if they have to stay there longer or if their time and attention is focusing on this project while they can't work on other projects or submit bids for other projects. You can sort of start to factor in those costs as well. Those can be a little bit hard to determine, and may not be awarded as much. But other than that, you have your other direct costs with your increased labor, material. If there's delays and you have to order the material later than anticipated, those costs are sometimes only good for 30, 60, 90 days. And based off of what you've anticipated at the time at the beginning of the project, you were expecting these materials to cost, $100 a pallet or something. But if you have to order them a year later, as we all know, material costs have gone up and fluctuated a lot. So that's an additional cost you didn't expect. Same thing with equipment costs as well. If you're having to rent this later, the cost could go up. And those are the costs that you're going to be looking at if you're a contractor or subcontractor. And again, liquidated damages, if those are passed down from the owner or contractor to you, if there's a delay, you could be saddled with a percentage of those. So we've mentioned this before, but your contracts are often going to have clauses that will limit the types of damages that you can obtain. And one of these is going to be a typical no damages for delay clause. And these are enforced in Georgia and in other jurisdictions. There's some variation on this, but it's a clause that states that the contractor, whoever it is, the subcontractor cannot claim monetary damages for delays. And the only remedy that you can get for a delay is the time extension. You only be entitled to that. And the clause is, as I stated, typically enforced, but again, there can be some exceptions for certain types of egregious behavior. These exceptions are typically going to run down to, the owner actively interfering with the work, making a bunch of changes, intentionally getting involved in things or delaying things. Another is if their delays become so long on the project that it essentially results in an abandonment of the project. If there's a stop work order that's issued, but just, nobody knows what's going on. The time keeps elapsing and there's no really excuse for the delay. At that point, you're looking at an abandonment of the project. And if the delays result from intentional conduct, which we mentioned before, bad faith, willful interference, things like that, that's going to be harder to prove because you sort of need that smoking gun. But they are rare, but those claims are asserted. And one other thing I have that's not mentioned on here is the limitation of liability clause. That's usually in contracts. That clause is going to limit damages recoverable, sometimes to both parties, but especially one party, where the parties are going to agree that, hey, you're only going to be able to get your direct damages resulting from, maybe negligence or intentional breaches, but you're not going to be allowed damages for your consequential and your indirect damages or punitive damages or attorney's fees, things like that. That's another clause that you're going to be looking at in a contract to see what can I recover and what am I prevented from recovering against the other party.
All right, we're running a little short on time. We got about 5 minutes left. I did want to mention this. As Chad has alluded to, project delays often create sort of a cascading damages effect because of the interconnectedness of the task on construction projects. So this is a real world example of what that looks like from a damages perspective. This is a stadium project. Our analysis concluded that the late design, fabrication, and erection of the steelworks caused the owner to incur damages of over 300 million. I won't go into each of these buckets, but primarily, the two big buckets there, 114 million for steel recontracting change orders. The subcontract for the fabrication and erection of the steel had to be converted from a lump sum contract to a cost plus agreement with schedule incentives to enable a more efficient execution of the steelworks. So at issuance of the relevant recontracting, the fabrication and erection of the steel were both approximately 300 days in delay. The second big bucket here is the 97 million for schedule mitigation. This is virtually all acceleration change orders, labor and equipment for everything but the steel, to accelerate the schedule to meet the new deadline. Obviously the season can't be moved, so the schedule was only pushed back a couple of weeks. So it was a significant acceleration. Just pointing out some of the other claims here, you've got additional steel. I mean, the additional steel only comprised about 4% of the claim. There's some other costs here. There's some remediation costs. General conditions were small because, as I said, the project was only extended another couple of weeks. Interesting point on lost profits here. It's only 1% of the damages, but it's interesting because the owner in this case had a very good argument that these are direct damages. I mean, everybody knew at the contracting of the stadium when the season started. That wasn't a secret. So it's reasonably foreseeable that there could be lost profits if that deadline wasn't met. As complex as this project was, the damages were very straightforward because of the contemporaneous documentation and the detailed change orders. Really interesting project. I'm going to speed us along here.
Probably skip that. I think we've talked
Yeah.
something about that.
Damages, I'll end on damages for termination here and then hang out if anybody has any questions. But two types of termination described in construction clauses or in construction contracts: for cause and for convenience. Termination for cause, typically permits the owner in most cases to terminate a contract based on an event caused by the other party, typically a delay or defective work, failure to pay subs, etc. And they can often recover the increase in cost to complete the project because they had to go out and hire somebody else to do it. Termination for convenience, really interesting concept in construction, or that's somewhat unique to construction law. The concept originated with U.S. government contracts during the Civil War. We ordered 1 million cannons. The war is now over. We no longer need 1 million cannons, so it's not in the public's interest to continue this contract. So that was kind of the context of how that originated. I'll briefly chat on this, and then I think we're kind of done. But the point on termination cases, whether it's for cause or convenience, is understanding what the contract says. You can see on the right side, this is a typical termination clause that I found on the web that's similar to a case I worked on in 2020. It says, in the event of such termination, owner will compensate the contractor for authorized costs incurred to date, reasonable demobilization costs, and authorized subcontractor costs incurred prior to termination. On the left is an example of a case that I worked on for termination for convenience case. You can see, I mean, the top 3 elements here. This is a steel fabricator who was terminated on a nuclear facility for convenience. You can see the top 3 elements. Work shifted from 2018 to 2017 to mitigate the loss from their suspension and ultimate termination. Work bought at cost. Steel shop hours lost in 2018. I mean, so those top 3 right off the bat, those are all claims for lost profits. All of that is, your losses would be what you lost in terms of profits on those actions there. And then obviously the last portion, the 1.86 million for lost profits, is a result of losing future work. So, the point being here, you can imagine this case didn't go well for the plaintiff. They ended up recovering about $270,000 on a $5.1 million claim, primarily because they didn't pay attention to the contract that they signed. The other part was the contemporaneous documentation was severely lacking. They didn't have invoices, support for a lot of the costs that they had. So I'll stick around for questions, and I imagine Chad will as well. We didn't get the lost profits, but they are in the slide deck. I also do a full 1 hour CLE on lost profits if that's of interest. Our contact information is at the end of the slide, so feel free to reach out, and I'm happy to present on that.
Thanks, Andy. Thanks, Chad. I think there's a question in the chat. I don't know if you guys saw that.
I don't. I'm sharing my screen, so I don't see the chat.
As to punitive damages not being recoverable absent tortious conduct amounting to a claim separate from a breach of contract, do you have any case citations related to that?
Chad, I'm gonna let you take that.
Yeah, I mean, not off the top of my head. It's usually pretty rare. But yeah, I mean that's a good question. But no, I mean I haven't specifically done any research on that.
And if the construction contract does not specify that that profit and overhead will be paid in the event of a termination for convenience, will they be subject or be allowed under common law?
Yeah, I mean if the contract is silent, and it doesn't prohibit anybody from collecting on your lost profits or consequential damages, then yeah, I mean you go ahead and prove those damages, and there's case law out there obviously saying that you can collect on those. So yeah, it's obviously throw all your damages at the wall if they're not prohibited underneath the contract.
I think that's all that's in the chat. Well, maybe.
Oh,
Oh, Jake Carroll.
Jake chimed in. Yeah.
Of course, he has a site on top of his head.
Yeah. Well, good.
All right. Well, gentlemen, thank you so much. Thanks, everyone, for joining us. Lane, I think we can conclude.